Okay. Christina, you're awesome. Thank you for the reminder there. Okay. Now we're ready. So this is the 2020 Fair Housing Webinar Series. This is the last in the fall series. We had 2 intermediate sessions on the 10th and 17th, and this is our final advanced session. And so this is basically covered under a Fair Housing and Innovative Partnerships Education Outreach Initiative grant we received from HUD. And as time allows, we're going to be discussing a range of issues. These are going to be questions coming from the audience primarily, and then elaborated on by the presenters. So special thanks again to the Department of Housing and Urban Development, attorneys David Penny and Eric Stephen for their time and expertise. I want to give a special shout out to Christina Carlos in IHFA's Marketing Communications team for helping get the registration invitations kind of organized and coordinated and keeping everything flowing smoothly. And then let's see, again, here's our acknowledgement and disclaimer. I'll let you kind of read through that. Again, this is funded by a grant from HUD. And the attorneys take full responsibility for everything they're going to tell you. Right, guys?
Of course.
Okay. We are recording this session. And so everything that folks say and type is going to be recorded as part of the chat as well. We're going to have everybody stay muted. If you need to ask a question, please type a question into the chat, and Christina and I will kind of monitor that and make sure we raise those questions to the attention of the attorneys. And let's see, you can ignore that second to last section. And today is that advanced session we talked about. These are our esteemed attorneys. And again, just quickly, IHFA has been involved at the state level in sort of planning and reporting for fair housing through housing and community development efforts with the Department of Commerce. And one of those responsibilities involves the state of Idaho assessment of fair housing, also known as the analysis of impediments. And the most recent version of that adopted an economic opportunity approach. As I like to remind people, fair housing is not just about civil rights, which is a really critical piece of it, but it's also about economic opportunity and making sure that everyone has what's called housing choice that helps them with employment and education and access to essential services and community assets. You can see some of those spelled out here. This presentation and other slides will be available at fairhousingforum.org. I'll show you that real quickly. You've got a Fair Housing Basics presentation. And I just looked this up just to kind of check the stats on it. When I typed in Fair Housing Presentation, this one had 31,000 hits or views, second only to one that had 60,000 views. So shout out to Christina Miller on that one, getting a lot of play on that. So once again, you can find links to these videos, links to the presentation materials at fairhousingforum.org. And I can take you there real quickly right here and just show you where you're going to find that. So this is what that website looks like. You'll notice you've got a search field here if you want to search for a specific topic. We ask you to check that waiver of liability before you go on, so you release everyone from everything forever. And this is just educational. It's not legal advice by the, I think you probably figured that out. And then let's see, we have, I think you can just type in, if we go to training, let's see, we'll just type in training here. And for some reason, the training's not showing up. I'm gonna put a direct link to the training information in that, in the materials we send out, so we don't spend a lot of time looking for that. So we'll stop sharing, and I'm going to turn this over to our two guests. Oh, let's see, we had, and then yes, we have a question about the certificates, and we will make sure that everybody gets that link. Christina's responded to this already, so thank you, Christina. And let's go ahead and turn it over to Eric Stephen and David Penny. And Eric, I think you are muted. Eric is still muted.
Well,
there we go.
There you go.
I hear him now.
All right. The first thing I'd like to say is that the advice we're providing is to the best of our abilities based on our experience, but this is in an intermediate session on fair housing, and I would expect your questions to go to your lawyer, either David or I or someone else, with all the documents to be reviewed that are relative to the situation, and have the nuances of your situation explored. Even if we talk about some case hypotheticals today, I still believe that we are better served if we have a chance to review the file, all the documents, tenant's lease, any written complaints from neighbors, that type of thing. So we will give you information, but I still think it needs to be vetted through your personal lawyer that has some experience with the actual case.
I would just add to that, that one of the things we've hit on throughout the prior two sessions is the importance of documentation. And really to get the guidance and legal advice that you would need to say, okay, I can now proceed with my circumstance or the issue I have with a particular resident or manager or whatever, would be incorrect, because whoever is going to give you that advice needs to be able to look at that documentation we're talking about.
Thank you, David. I don't even look at or provide advice to my clients without seeing the whole file. And so that's kind of an aggravating factor to some of my clients. But I really think it goes to providing informed advice and informed consent for the client to make those decisions. They're really critical. And this is an area where it's really easy to get sued. So you want to have good, competent advice, and you don't want to shortchange anybody's ability to provide that advice.
At the end of the last session, we were talking quite a bit about, what to do if discrimination occurs. And then we also wrapped up very quickly about, fair housing enforcement. We've talked some about the filing of either administrative complaints with HUD or the state agency, and then HUD's investigation, and then what happens beyond that, and the rights of the person claiming discrimination. But one of the key things that here again throughout both sessions I think we've talked about is the importance of communication and how quickly communication can go south. The wrong email gets sent, and the next thing you know, it's triggered or prompted the HUD complaint, or in some cases even a lawsuit. And I think it's important for us to step back. You can know the law, you can have a good attorney who advises you on legal matters, but the frontline communication between the site manager or the property manager or owner landlord and the resident is key. And when you're in that management or professional position, in my experience, and Eric can jump in here, certainly the judges hold you to a little higher standard. You're a professional. It used to be, well, there was a general idea, almost anybody could be a property manager. That's no longer true today. Today, it's a professional position. And as the professional, you have to communicate effectively, and you have to be above the fray. And that's also advice on how to avoid fair housing complaints going forward, is that stick to the facts. Don't make it personal or let it get personal. If you're about to send an email and you don't know whether you should or shouldn't, let it sit or get somebody else to read it. It's the person who's got a lot of irons in the fire. They're dealing with a lot of different residents. One of them is kind of putting them through the ringer, maybe hostile in the interactions, and the wrong thing gets said, or an email gets sent that shouldn't be sent. And in that situation, it's perfectly avoidable to just get out of the heat of the kitchen for a little bit, think about it, and realize what your position is as that management professional, and avoid making that communication mistake. I think that that's one of the biggest issues that I see that reoccurs. And when I say I see it, I've seen it for 25 years. That communication often leads to the HUD complaint. Poor communication.
I think those are good points, David, and I think you and I are on the same page. That you brought it up at the beginning of the presentation. Documentation. I think there's a little bit of naivety with some managers that they think that everybody will understand what's really going on at the property and what's really going on between a complaining tenant and some other residents. And the reality of it is your ability to paint that picture of what's going on at your property has a direct correlation with your documents. You're not going to necessarily sway a judge or a jury with your testimony that's just so persuasive. You really are assisted in a great way by your documents, because your documents tend to appear a little bit more objective in a lot of situations. They help show that, hey, there's been this pattern of conduct that started at this one point. It's continued to precipitate, and now it's at this other point. But if you haven't done good compliance notices, you haven't solicited complaints or preserved complaints from third parties about specific tenant conduct, I think you're really opening up the door for that picture to be painted in a negative way towards your conduct. And I think David's exactly right. We live in interesting times, and your managers and your maintenance have got to understand that they have apparent authority to act on behalf of the principal. Kind of goes back to what we talked about at the end of the last session when I made the comment about, if you're accused of housing discrimination, don't race to go fire your on-site manager. That might be one of your only witnesses and stuff to help rehabilitate what's been going on here. But it's all about your documents. It's all about how well you've preserved the facts and the issues that have been transpiring at your property, and preserve that information and those facts in the form of documents that are going to appear to be a little bit more objective, or at least, solidified in time, showing what happened when, and at least the actions you took based on your perception of what was going on.
So often these types of cases, whether you're in front of a judge in a courtroom and a jury, or whether you're just responding in writing to a HUD complaint or a complaint with a state agency, is the appearance of reasonableness. And very often that's what decides the outcome in a case, in that each side has a set of facts and they're arguing back and forth. Maybe there's some emails, but there are also conversations. And a person says, this person says this person says that. And the judge is trying to ferret their way through this and decide, who to rule for. Is that if the things that you've said, those things that are captured in writing in the emails or notices of lease violation, whatever you might have given that you put in writing, if those are threatening, if those contain exaggerations, and are unprofessional, you come across as unreasonable. And that could sway it or push the judge to rule against you. But on the other hand, if you've kept your composure in your written correspondence, you've stuck to the facts, you've stuck to your position and rights as a manager, then you come across as reasonable, your chances are far better.
I'd like to share a story of a case I had, and I think it was it was probably a decade or so ago, but it was a case that I got from another lawyer. He said that he was really being treated in a vile way by the Human Rights Commission investigator. It was a steering case, and it involved a tenant by the name of Lisa Smith, who was complaining about a family next door to her causing all sorts of noise, and it was a large family. The leasehold premises was situated in an area that was multi-zoned. It looked like an industrial area, if you will. And the landlord had a lot of problems with noise with this family. So he went and talked to him and said, hey, I'm having problems with noise. I'm going to have to terminate your tenancy. And at the same time, hey, I got another house that you could potentially live in that's not a sixplex like this place. It's a single family dwelling. And the tenant, the family tenant that was making the noise turned around and sued the landlord for housing discrimination on familial status, and then also sued him, accusing him of steering, saying that he had suggested that their Latino family would do better in an area that was predominantly comprised of Latino people. I went down there. The case had been going on for a year before I got involved. It had been really protracted. The investigator treated me like terrible. It was horrible. But anyways, I go down there to see the property, and I see that the sixplex is in this multi-zoned area. The house that they were steering to was in a really beautiful area that was part of the corridor that had been renovated recently and stuff. I took a bunch of photos of the alleged target dwelling that they were being recommended to go to. And by sheer luck, the day I was down there, there was a yacht in front of one of the neighbors, and the whole block looked beautiful. But what I got out of that was the landlord never gave any notices to comply or vacate to the family with children that was causing noise. The landlord never preserved any of the complaints made by Lisa Smith, the complaining tenant, and never got anything in writing from her talking about the noise to corroborate that there was an allegation of a problem with the family with children. And then Lisa Smith, lo and behold, moves and can't be located. And I ended up getting the case dismissed, but it just struck me as a great illustration of the lack of diligence by the landlord in failing to issue the notices to comply or vacate for the noise disturbances, for failing to preserve any of the dialogue or the complaints from the complaining tenant, and how that really set that landlord up to get sued for housing discrimination. And had the landlord done his work in the beginning the right way, issued his compliance notices, preserved the third-party written complaints corroborating that there was a noise disturbance, that fair housing claim probably wouldn't even have got off the ground or gone anywhere. Instead, it took a year and a half for it to get dismissed. So anyways, I think it's a good example of why you need to be diligent in exercising your rights as a landlord, and why you have to issue comply or vacate notices at sometimes, even if you don't want to evict the tenants or the family, you've got a duty to enforce the rules for the other tenants and the other residents. And if you're remiss in doing that, you're opening up Pandora's box for claims to be made against you because you haven't been diligent in your documenting.
What do you think? Are we ready for a question?
Yeah, I'd say so.
From before.
If anybody has questions, type them into the chat section. We got a couple by email yesterday, I think, and these have to do with HOAs, and I'll just read through them a little bit, and you can kind of decide how you want to progress on these. One is, could you elaborate on how the fair housing rules apply to HOAs? I know that in the past we've seen CC&Rs in Idaho that still have some outdated language that's pretty offensive, probably written in the 50s and 60s. That clearly is discriminatory language. So every once in a while you come across those. And this the second part of this is our HOA has prescribed design policies and procedures for requesting approvals. I know consistency is the hobgoblin of little minds, but sometimes our lack of consistency concerns me. Let's see. And I guess you kind of get the idea. You want to have some consistency in those policies and procedures. You want to address that.
You know, it's disparate treatment, and fair housing absolutely applies to these HOAs, in my opinion. And the section that talks about the question says, sometimes committee members reviewing a proposal without the required drawings or information will simply say things like, I know the merchants, they have good taste. I know it'll look great because they are so careful in their choices. That's disparate treatment, folks. You got to follow the rules, and it's got to be done in a uniform manner when it relates to enforcement. David?
Yeah, so I think there are really three areas that HOAs could potentially run foul of the Fair Housing Act. There may be more, but certainly the big ones are your CCNRs that are recorded as a document in the county recorder's office that apply to properties that are conveyed. It's of record. And then the rules that an HOA board develops to govern usually conduct and the way that the community is going to operate. And then lastly, the enforcement of those rules or of the CCNRs. And those are the areas, you know, I think a lot of what happens with HOAs, you've got a volunteer group of people at the board. This might be a little stereotypical, but they like to meet and drink coffee. They have their group of friends who are common to them. And usually the problem arises, there'll be one person who's perceived as an outlier, or their situation makes them an outlier. I think in one of our sessions, we talked about the example of it's not a senior citizen development or community, but the folks tend to be of older age. There are no children there except for a grandparent for some reason ends up with their grandchildren coming to live with them. And all of a sudden there are rules. People don't like it. And that's a difficult area, and an area that's fraught with problems, because rules against noise, leaving bicycles on a sidewalk, pool rules, adult swims, who can be in the clubhouse. These rules then all of a sudden seem to develop around the outlier who has their grandchildren now living with them, and how the board's gonna protect the peace and quiet of the rest of the residents from children being in the community. So I think that's often where you end up with these issues, and it's familial status discrimination is probably one of the most prevalent ones that occur. The others would have to be, fairly, before I get on to the last point, the other point would be the second most prevalent area would be disability discrimination, and a community that has either a no pets policy, or perhaps they allow pets, but they allow Fifi the toy poodle because they have restrictions of height, size, breed, those type of things. And they then have somebody requesting a service animal. And as we all know, you can't apply height, size, breed restrictions to a service animal, yet they would go and do it anyway. The last point I was going to get to is that probably in a minority of cases, very few cases, but it still exists, is people want to apply rules that are going to have other types of discrimination, national origin discrimination, maybe race type discrimination, might be religious discrimination. If people don't like a family's decorations that they put up in their celebration of an unpopular holiday, for example. But it's imperative that that board with an HOA get fair housing training. And here again, HOAs don't like to spend money, but we've talked about numerous times HUD's fair housing basic training, and it doesn't take rocket scientists to apply the same things that Christina Miller talks about in that training about landlords. Take landlord and management company out and insert homeowners association into the examples and the discussion, and it would apply. Because you're both managing, overseeing, determining access and use of real property, you're going to come within the Fair Housing Act.
I had a case years ago, Dave and folks, where my client had a HOA or condo association. They had a community fitness center, and the fitness center was divided into two halves, and one half was for men and the other half was for women. And they got a complaint because they had more equipment, including a row machine, on the men's side and not on the women's side. So there's another kind of way it could come in there with gender discrimination, and the association had to work through that issue and actually remodel the fitness center to be closer in facilities offered to both gender.
Yeah. I think a lot of HOAs too, again, not wanting to spend money, which we can all appreciate, avoid having legal counsel go and review their CC&Rs and their rules. And it's money well spent to have that done. And so I would encourage, if you're an attorney advising a board, to look at their documents. If you're on a HOA board, to certainly prompt that you don't have to spend money every year. You can do the free training, but have an experienced attorney go and review the documents that are using and those rules, and help avoid problems in the future. It would be money well spent, and hopefully would not be that expensive. So, Eric, if you have anything else on that, I noticed one of the questions was about COVID-19 rules, and somebody who doesn't want to follow, I assume, a property's rules based on religious beliefs.
Before we shift into that, David, just real quick, leaving your topic on the HOAs, I believe that one of the sentiments that you'll probably hear, or at least I've heard a few times, is that, hey, these CC&Rs have been fine. They were done 30 years ago. We haven't had any problems. So why in the world would we look at them now? And I think that's probably not a realistic or a best practices type of mindset in dealing with those. And I echo David's comments about having your CC&Rs reviewed and make sure they're up to speed and look for them. You can just give them a cursory review and look and see, do they have some outlandish provisions that relate to children or certain protected classes. And then finally, there's a dynamic that comes up in a lot of the HOA or condo association situations when a owner of one of the units rents it out, and then you have the condo CC&R rules that apply to the owner, and then you have the rental agreement or lease that applies between the owner and the tenant. And there's got to be an alignment of those rules, and the owner needs to bring in those CC&Rs, if nothing more than conceptually, to align with the tenant duties and that are outlined in the rental agreement and the rules, to make sure that you're able to enforce the actual legitimate rules of the HOA or condo association where the property is situated. So I just wanted to leave that on that side, and then we can go into this COVID stuff and people that are refusing to wear masks. I've seen some documentation from, I believe, the government that talks about, actually I saw some protocols the other day under the ADA relative to people that refuse to wear masks and the need to grant accommodations to those folks, which I think creates a fairly difficult situation to resolve. What I saw was that they were trying to get people to use alternatives. So if somebody refuses to wear a mask and they want to come into a retail store, maybe suggest, hey, we could give you curbside service, or we can help you in this way, but we really want you to wear a mask if you're going to come into the store.
I mean, here again, this is an issue of problem solving and trying to find a way. Sometimes it's not whether they're right or they're wrong, and, whether this is truly a religious belief that would that is protected under the Fair Housing Act, such that it would be discrimination to base some decision on their position or not. It's still somebody coming to you and saying, you have a rule and I have an exception, or what should be an exception. And so whether it's curbside service or another way to address it, then certainly you should be looking for those alternatives, because again, you don't want to end up and you're diverting your time and effort and resources if there's a HUD complaint about it. So you want to resolve it. Not knowing exactly what the religious belief would be, or if it's concrete, or whether just someone reaching their own conclusion that their religion would prevent them from complying with, for example, a mask mandate. The rule of COVID-19 requiring the mask mandate is neutral. It doesn't have a religious purpose. It's applied to everybody across the board, and as long as you're applying that to everyone, your rule is neutral. So the question would become, does it have a disparate impact on people of a particular religious faith? And those are excruciatingly difficult, certainly under guidance issued this year through HUD, extremely difficult to prove. So, there are exceptions to what I'm saying, but I think for the most part, in most cases, you would be able to insist upon compliance with your COVID-19 requirement. But in saying that, I would hope that you would try and find a way to meet some middle ground so that it's not an issue.
I think this is Eric Kingston. I think there's a couple things going on. We did have another follow-up question that talked about folks that are claiming a medical issue that prevents them from wearing a mask as opposed to a religious belief. Right. And, then you're getting in, I think to some extent, you're getting into ADA law, and the ADA has some statements on that. I'll go ahead and post some of those links in the chat as well, but maybe you can kind of talk about the distinctions there.
We talked about that earlier. Places of public accommodation are subject to the ADA with respect to disability issues, and that's where I believe that you need to look at alternative ways to accommodate that disability if they're refusing to wear a mask. I saw a hypothetical the other day about a grocery store, I believe it was, and somebody was talking about how it would be a fundamental alteration of their business policy to allow somebody in there without a mask during the pandemic, and that they should consider alternatives such as I talked about before, curbside assistance or maybe delivery.
Yeah, so here again, someone says they have a medical reason they can't wear a mask. Hopefully the first thing is just try and resolve it. Come up with a way to provide the service or that that addresses their concern, because we're in a service industry to begin with. The second is, though, if this person has a disability, if they have a disability and they're making this request, then you're into the request for accommodation type of analysis. And you can seek verification that they have a disability and that there's a nexus between their disability and what they're asking for, to be exempt from a mask wearing policy, for example. We know they have to get either a disability specialist or medical provider to verify that. And that verification has to come in writing. So you have those steps. And then we also know that depending on that outcome, if you're going to deny it, is the interactive process where you should be communicating with them about, is there another way? Is there something else you can do as an alternative accommodation that would meet their needs other than what they originally asked for? So I think that's the analysis that you're going to go through. If it's not disability related, then the Fair Housing Act doesn't dictate what you have to do, because we know that you have to have a disability to be a member of the protected class. So I think that's the analysis that you would apply.
I think, David, wouldn't you say that that analysis applies if we're talking about common areas of a multifamily dwelling or something like that? But the Fair Housing Act is not going to apply to the grocery store
No.
or retail shop or something like that. That's where we're going to get into ADA issues, I believe. Is that correct?
Yeah, the ADA, that's the shopping center or restaurant, place of public accommodation.
Perhaps your business office?
Business office, yeah.
For the apartment complex?
Well, I think that there's a good argument that if people are seeking housing services and make a request for accommodation, that the Fair Housing Act does apply. So if someone's not coming there for a housing related reason, then I think the ADA applies. But if you're at, like, say, an on-site rental office for the apartment complex, and somebody who's coming in as an applicant or somebody who is a resident there, and they have to have a assistance animal to pursue housing, either as an applicant or fill out a work order or whatever, I think that the Fair Housing Act would require you to allow them to do that.
So in that situation, I think both the ADA, the Fair Housing Act, and perhaps 504, the Rehabilitation Act might all three apply to something like that, depending on the logistics. Go on to the next questions. Eric?
Okay, let's see. You wanted me to continue with the HOA questions?
Let's go to something else, I think.
We've got a few things here. Looks like, and I've tried to post a few little bits of research that I found as far as some of the legal considerations on the religious exemption and the ADA exemption, which both appear to be sort of labeled as false when people claim that they have an exemption for this under the ADA or under the Civil Rights Act of 1964. As far as other options, somebody says if they can't wear a mask, ask them to at least wear a face shield. Let's see. Those are the ones we've got in the chat box at this point. As far as the HOA, if we go back to the HOA, the existing questions we've got, and I just want to encourage folks to post additional questions in that chat. Let's see, you mentioned in the first session that renters, and that in an HOA could commit fair housing violation regarding a renter who's, like subletting a property in the HOA. I think, did you talk about that already?
Well, that could be a situation where the CC&Rs say no children using the pool.
Yeah.
And then the owner of the property has a tenant, and the tenant has a kid, and the kid wants to use the pool. And then the HOA comes down on the owner and says, "Hey, you're violating the CC&Rs." And then the owner is going to say, "Well, your CC&Rs are discriminatory, and I'm not going to follow them." And so I think that's one hypothetical. David?
Right.
Or the worst case scenario, the owner does follow the heat from the HOA, and then the HOA and the owner both end up the subject of a fair housing complaint. So yeah, just because your HOA says it's so doesn't necessarily mean it. Certainly, if you've attended any of these sessions or you're knowledgeable at all in fair housing and you hear the HOA say something that gives you pause, then you're on your own to decide whether they're complying with the Fair Housing Act or not.
A lot of those CC&Rs have been around forever, guys, and they probably are a little dated if they haven't been revised in the last 10 years.
So I just wanted to kind of follow up on some of that, the masking issue. I guess if you took, you created an analogy to say some other practice that poses a risk to health and safety of either the tenants or the the site management or that kind of thing. I would think the same things would apply. If somebody says, well, I'm going to choose to, I don't know, do something else that's threatening the health and safety of other people, and I'm claiming a religious belief, wouldn't that be the same thing? If you're exposing folks to a risk.
Well, and I think reasonableness comes into the thing, and that, was talking about a lot of different factors. We never really got to reasonableness, but it has to be a reasonable request. And if it's a per se unreasonable request, then that's part of the assessment as well. The problem is unless it's really, really out there in left field, I usually don't like to call in the reasonableness of the request. That it would seem like that's one of your first lines of defense, but it seems to me like in my practice, it comes later in the assessment. David, what are your thoughts on reasonableness?
Well, I think one of the first things, if I were a manager or an owner who was faced with this question, would be to ask for the person to elaborate on the basis for their claim that this is a religious belief, so that you can understand it. This isn't a request for accommodation, as we all know, and we're not asking about a disability, which you can't ask about with a request for accommodation. But here you certainly can ask for them to provide the explanation for and the basis for the belief. And I think that bears on the question of reasonableness. Eric Kingston's point is that then on the other side of reasonableness is, what is the goal of the prohibition? If the idea was, and this is getting out there a little bit, but I want everybody to wear a mask because I think masks look really good, and we're going to have a photo shoot of the property, and when the photographer takes pictures, I want everybody in it to be wearing a mask because I think it looks good. And somebody says, well, I don't want to wear a mask because of my religious belief. Probably not reasonable. So there you've got the balance. But when you're saying, I need everybody to wear a mask because we're in the middle of a pandemic, the likes of which the world hasn't seen since 1918, then the balance is stronger. What's the reason behind the mask? And what's the purpose that you would inconvenience somebody's religious belief?
And David, wouldn't you say that's so because there's empirical data that supports the position that masks have some ability to control the impact the spread of the pandemic. So you'd be relying on evidence, or you'd have evidence available through empirical data to show that there's a medical benefit to your policy, which I think goes a long way to support your claim that not wearing the mask would be unreasonable. Hey, Dave?
Yeah, absolutely. Yeah, that's as opposed to the first example is subjective. I think it would look better if everybody wore a mask for the photo shoot or picture. That's subjective. There's no empirical data on that. But the example of certainly battling the spread of COVID-19, there would be empirical data.
So we do have a new question, non-COVID related, and that is, what are some of your recommendations to managers on how to ensure that their offices and employees are complying with fair housing, in addition to just providing testing? What about like a certification or some kind of a follow-up? I mean, these are my kind of thoughts, to create a sort of a series of questions that test knowledge on some of the topics. I mean, are you aware of anything like that, or what else would you recommend?
I think that all goes to training, and I think the testing is just part of the training. I think you got to train. I think you want to train with diverse training providers so that you get the message from a couple different sources, and you get the different take. The thing about lawyering that Dave and I enjoy is that it's all about our opinions, and our opinions are impacted by our experiences, but our experiences are defined by the people that we've interacted with in those experiences. So, I think you got to really look for a diverse cross section, and then train, and continue to train because it's fluid.
Yeah, and we've talked about the training with HUD, but there are people that you can hire that do training who also their training comes with a test. And so online, I know Terry Catay's company, the Fair Housing Institute, I think is what they're called, and they're referenced on the Fair Housing Forum page as well. They do training where there's a test at the end. So, what's the retention? I think somebody in management, you can test your own people in place to find out how they react to circumstances. I think one of the best things you can do is make compliance easy. And for example, we talked about LEP requirements and the properties, HUD project-based and RD properties that have to comply with LEP requirements. Make sure that you have language line or some other translation line already set up for a manager to call. Have the process and the numbers laminated and taped to the top of the desk by the phone. Have a set policy for how you're going to process requests for accommodation. Don't hand somebody the stack of HUD guidance, but have the simple steps so that compliance is easy.
I always want clients to just recognize issues, and I think training in large part is to make sure that your managers see the red flag or smell something funny when the issues present, and then reach out and look for the expertise or the guidance after you at least identify the issue. I don't expect all the managers to know this stuff cold. David and I don't know it all cold and can't just, pull it out immediately, but we know where to go to find the answers to the more complicated hypotheticals. But I think you gotta really be vested in training for issue identification. And then, as David said, have the resources like Gary Haynes and for LEP or LAP stuff, or whoever it be, David or myself or Terry Catay, who I refer to as well. That goes a long way. You don't have to know all the answers, but you dang sure better be able to spot all the issues. And what bothers me and what I see as one of the most problematic dynamics in housing is clients that react to situations very quickly, but without looking for the resources or counsel, and then come in late and say, what do we do? And I talk a lot about the hypothetical of baking a cake. And I can do a lot to help you with the cake before the batter is in the pan and in the oven. But once it's in the pan and in the oven, then I'm just going to be putting dressing, icing on it and changing how it looks, but I'm not going to be able to change the composition. So I think identifying issues, reaching out early before you take action, not after you take action, I think that's a critical part of the equation.
Well, and I'll go ahead and share screen briefly because we do have an LEP
another
section.
thing I can add to that, Eric, and it just popped to mind, and that is you can go to HUD.gov, and at their website you can find where they have examples of housing discrimination. So if you want to test your employees or your managers, find that sheet that has, and they have lots of examples, by the way. I mean, it goes on and on. Pick a couple of those examples and have a manager sit down and look at that and just write out for you a paragraph of how they would handle it. So there are no cost to low cost ways that if you want to test your own staff, or certainly have, I don't know if you can have meetings anymore or not, but one of these days you'll be able to have a conference and a meeting with folks as opposed to an empty conference room, and sit down once a week or once a month and read off an example of housing discrimination from that website, and sit down with your group and discuss it and hear what's being said by the people around you. And that could be a way to find out if the training's actually taking hold.
David's making a good point about just having policies of inclusion and just awareness. You know, if you're addressing the issue with inclusive posters in your office, and you're talking about it and making it part of the game, I think you're going to be a lot more in tune with it and aware of it when it does present, or when the issues present. You'll be able to work through them, or at least identify them, like I said.
So I'm going to go ahead and share the fairhousingforum.org site one more time and kind of give folks a little idea of where they might go for some of this information. Okay. So can you see that website, Christina and Eric, David?
Yep.
Okay. So up in the sort of the upper right here, there's actually a little yellow box that says limited English proficiency. If you click on that, and there's a couple links to this, and this gives you some basic information about this, along with some resources down at the bottom. So the idea we've kind of pushed is that good customer service is welcome in any language. It means, you know, you're just trying to provide good customer service to everybody. And you know, you guys can talk a little bit maybe about vital document translation, and you know, what's the threshold. But there's a lot of information here for property managers and housing providers. You can get there a number of different ways. And then if you look down on the right side, there's some links here, topical links. There's resources. If you click on that, resources on accessibility, on civil rights defense. You know, you've got a link to Eric Stephen, you got a link to Terry Kate, Fair Housing Institute. You know, so lots of resources out there. Disabilities and fair housing. You know, people that are interested in filing a complaint can go here. You know, lots of different things. Language and cultural resources. You mentioned Gary E. Haynes Associates. You click on that. Gary's got a really good kind of collection of information on LEP information, or limited English proficiency planning. So lots of resources there. But that's, you know, that fairhousingforum.org site, I think, is a resource. We'll do what we can to keep that current. IHFA kind of manages that as a courtesy to everybody. And, you know, if you've got suggestions for things that you'd like to see on it, please let me know, and do my best to keep everything current.
Kingston, I think that's a good point. I think it echoes back to what David said at the beginning, where housing management is a profession now. It is not just a job. It's a profession, and you need to be a student of the game because it's a profession that's getting more complicated by the day. And I think as on-site managers, you got to look at this as my glass is half full and I've got more value now, not as hey, it's too complicated, I want to get out. You got to raise your game and try to be the best you can be. But, you know, when I was in college, I sold men's suits at retail stores, and there were a lot of old guys that were professionals that had been selling suits for a long time, and that industry kind of phased itself out with our economy. But fair housing is just the opposite. This is not an area, I think this is an area that started out as a retail job and has turned into a profession, and it's getting more complicated and more complex by the day. And it requires you to be a professional, to buy into that mindset, and to be a student of the game.
Maybe you can sell Eric Kingston a suit. That would be. Well,
that'd be your big test.
Yeah, I would mention to folks too, and this is kind of an attaboy for the managers out there, you know, somewhere around, and this has nothing to do with fair housing, but somewhere around 95% of the people that are tenants and a property you run appreciate the work you do, appreciate living where they live, and have a lot of respect for you and the job you do. So often the training or these sessions or something else is about how you've got to do something better or something that wasn't done correctly and how you've got to change. Here again, that's part of being part of a profession. Lawyers certainly see that every day. But you got to know, no one has a seminar about congratulations, 95% of the people think you're wonderful. But I just want to tell you, it is a high statistic across the board that people do appreciate the job that property managers do.
I take that a step further too, David. I think you're right. And I take that a step further. And I tell you that, you know, whenever I talk to any of my clients, especially at the introductory phases, I always preach about running a tight ship, about on-site managers walking the property every day to make sure the grounds look good, and by exercising diligence. And I think that the tenant composition, they might get a little disappointed with you giving them a reminder notice or a compliance notice when they don't bring their garbage cans in on time or whatever it is. But if your community looks shipshape, I think it goes a long ways. And one, a happy tenant composition. Two, I use in all my enforcement strategies, I try to use good tenants to help expel bad tenants like antibodies. And I always want my manager to have a real positive role in the community as much as possible so that they get support from the good tenants to help exercise and get rid of bad tenants. And I think a lot of that has to do with just, you know, starting with walking the grounds, starting with being diligent in your enforcement. Make sure you encourage civility and communications between your staff, and it's not just us against them, you know, but opening up the lines of communication like David talked about earlier. I think those things go a long, long way in minimizing your need to respond to fair housing complaints as well as other complaints. And I think it helps what David was talking about, generate that goodwill at the property, and there's usually a lot of it. But you've got to, I think you got to foster it too.
Another issue that ties into this is fracturization at the property, and that one of the communications that everybody at an apartment complex sees is the relationship that management has with the other residents. And it's not just the site manager, but the maintenance person as well. If, you know, the advice that I often have given is when it comes to your site, even if staff lives there, be friendly, but not friends. You can't sit on another resident's patio having a cocktail at 7 o'clock where everybody else is walking by and expect to correctly manage that apartment complex. It just doesn't work. Your maintenance person should do maintenance work based upon submitted work orders. They can't go to their friend's apartment, drop what they're doing, and walk in and do things without without an order, a work order, whereas everybody else is required to submit a work order and wait in line. So one of the communications isn't verbal and isn't written, it's conduct. It's the conduct by the people at the property. And that does tie in with fair housing, because let's give an example that you have household A that the manager's very friendly with and everybody sees it, and household B, and let's say household B is their national origin is Somali, for example. And maybe they also have a language issue, and maybe we're also at a HUD project-based property. So these two households have conflict, and they're making complaints about each other. And one of the issues is that the manager is tight friends with household A and not with household B. The managers compromise themselves. How can they investigate the claims? How can they fairly enforce the rules? Where are they going to be in their testimony if household B ends up filing a HUD complaint? So that's just an example of how that you can be friendly with everybody at the complex that you manage or you're the maintenance person with, but you can't be friends. You got to find friends someplace else.
I think those are excellent points, David. And one of the things I always see and talk about is the clients that have smokes and cigarettes with the tenants and hang out in the smoking lounge or coffee, and or play cribbage or they play board games with a group of tenants on a regular basis. As warm and fuzzy as that sounds, I think it's a bad idea. And it's a bad idea because sometimes those interpersonal relationships go south if they transcend beyond the friendly, not friends, all business type of setting. And then they get into, passionate arguments about politics or this, that, or the other thing. I had a client years ago that was sued because the on-site manager hugged some gal. Well, the gal that she hugged communicated by lip reading, and she was deeply offended when the manager hugged her and she was trying to communicate with the manager by lip reading or signing. And, I don't go around hugging people that I don't know really, really well. And I certainly wouldn't recommend that for an on-site manager at a property. But sometimes well-intentioned behavior can go south on you and get you into hot water in these scenarios. And it's typically, in my experience, when you're acting different than you would as a professional. Because like I said, most professionals just don't go around hugging everybody that they run into during the course of their work. So I believe David's point, friendly, not friends, is absolutely spot on. I think it's a big, big issue in fair housing. And his comments about disparate treatment are absolutely right on. I've had the cases where the tenant that I'm evicting says, well, you're evicting me for my kid smoking marijuana, but my kid smokes marijuana with your on-site manager's kid at your on-site manager's house. And you get those kind of argument or allegations, and you're like, oh, gee whiz, didn't see that coming. But it's a great example of dropping the ball on this friendly, not friend stuff.
Well, this is Eric Kingston. I would just kind of echo that. I mean,
management things that when Eric and I get together and give that advice, we didn't learn that in a law book. We learned that from seeing how cases develop and how the issues roll forward in response to like a HUD complaint. And so it's better to learn these lessons up front. A lot of it's common sense, but common sense isn't common. And if you're in management, you should have a policy with regard to your site managers and maintenance. And, you know, the big words fracturization, but a lot of it just is professional conduct. And that should be part of your employee handbook, and it should be part of the training you're providing to people.
Hard to get that across sometimes, wouldn't you admit, David? I mean, because people think, oh, well, you're just telling me just because you're a jerk doesn't mean that I have to have all my staff be jerks. What if they just want to be, you know, gracious and stuff? And I got to tell you, one of my clients is a huge property owner, owns most of the town I live in, and some other ones as well. I've seen the guy get sued one time in 30 years for any kind of housing discrimination complaint when he's got more units than anybody else. And it's because he does business like the bank. His team is incredibly professional. And one of the things that I see from them that I think is a big indicator in landlord-tenant relations is your diligence in performing work orders and performing them in a professional manner promptly and stuff. And I think the good management companies are really hyper vigilant and diligent in performing work orders, doing them in a professional way, and treating the tenants with dignity and respect, but in a professional manner, friendly, not friends. Again, like David said, he's exactly right. These are lessons that we've learned through watching other people's hard knock stories to some degree.
So this is Eric Kingston. I just want to echo what you're talking about there. And for those of you who don't know, one of my jobs since 1998 has been running the housing hotline or the housing information line for IHFA. So lots and lots of people calling me over those years. And I hear this a lot from folks that are complaining about favoritism on the part of a site manager or maintenance person in a property. And I'll bet a lot of those wind up being complaints. So I think what you guys are saying is really prudent advice. So in the absence of other questions that I'm seeing, I'll throw something else out that came through as a housing hotline call years ago. This was probably 10, 12 years ago. And it involved an apartment complex that typically takes lots of refugees. Boise's a resettlement agency or resettlement community, has been for decades. And the woman who called me was a site manager who really enjoyed having the refugee population and the tenants there. She said it added a lot to the kind of complex, and she really enjoyed the people. But she was had a complaint filed claiming that she was involved in steering because you know, they had a large population of folks from, I can't remember the country, but maybe it was, we'll say Burma, and she'd always been told to take the next eligible tenant or next eligible applicant that walked in the door. And, you know, a lot of people from Burma were coming through the door for whatever reason. And so she was told that that was a problem and she shouldn't be taking so many people from Burma. And so she was confused. She said, well, this goes against everything I've been told in terms of fair housing. And so she was kind of flummoxed by that. And I guess, you know, what are your thoughts on something like that?
Well,
list.
Yeah, I mean, there are a couple of things going on there. One of them is that based upon what you told us, is that her reason for the number of Burmese people moving into the next available unit is she had a policy, hopefully in writing, or procedure that's the way she did it, and that she has documentation of the applications she's receiving. She's vetting those applications according to a policy and procedure. And so that she's not doing this based upon their national origin or, you know, another protected class status. She's doing this just because the data, the facts, the documents, the policies and procedures created. So certainly in that respect, she's not violating the Fair Housing Act, the fact that it, happens that way, she can defend it. And so that, and her policies and procedures are neutral. Is she having some disparate impact here? Again, there's not an alternative. Now, if you look back at her applications, and she had, one from Burmese, 3 are national origin, 3 American national origin, 2 Romanian national origin, or whatever, and this was happening, she would have a much harder case. But kind of goes back to that documentation that we're talking about. The steering that I've seen over the years that pertains to an influx of people of a certain nationality was that a management company had multiple properties and processed applications, but they were taking, for example, I think it was Bantu Somali people, and were acting under the assumption, or having been told, that those folks all like to live together. And so instead of offering their full portfolio of possibilities, the people would arrive after traveling for unbelievable amount of time from a refugee camp, and were just put at that one property. They're numb when they get off the plane in Boise, Idaho, don't know anything, the help's been marginal over the years. And so that's where they went. And so in that situation, you do have somebody who's making a prohibited determination, and they're saying people of that national origin, that's my basis for my decision to put them over at complex ABC, because I think they all like to be together.
Right, and I think, David, what you described is pretty much how it was presented to me, that, she was just going based on the, next applicant walking through the door that met their eligibility criteria. And I think in exploring this a little bit at the time, what was going on in Boise and has gone on in the past is that, there are a limited number of properties that accept, low to moderate income tenants and have vacancies. And the refugee resettlement groups or agencies working within the area, they're anxious to make sure their people get housed. And the resettlement policies at that time are that those people have to be housed the same night they get off that plane. When they arrive in Boise, they need to have a rental ready for them. Pretty tough right now, but back then we had some vacancies. And so I think that was part of what was going on, that kind of directed, where people were just sent to places that typically they were known to have vacancies, that were known to take a voucher or to have a reduced rent, and it was a matter of convenience. So I think that was probably what was going on. We do have another question. Can you speak to the fair housing complaint process and how long it takes to complete a case, and how damages are determined if a housing provider loses? Also, some of these cases end up in federal court. How does that happen?
Can I take the first part of that, David, and give you the second part?
Jump in there, chew on as much of that as you want.
All right. So it starts with somebody filing a complaint with HUD or Human Rights Commission, and then they send out an investigator to determine whether or not there's reason to believe that cause for discrimination occurred or no cause for discrimination occurred. That's supposed to be done in, 90 days or 120 days? In every case I've ever had, I think I've gotten a letter from HUD saying they aren't going to meet their deadline for completing the investigation and they need to extend it. Then ultimately, after you get a cause determination, then there's an election as to whether or not it's going to go before an administrative law judge or to a federal court jury trial. At that point, the Department of Justice for the United States gets in if it's HUD, or the state attorney general if it's going through a state process, and they can take the case. If you go to the either one of those two forums, we talked earlier in the presentation about inviting conciliation in these matters before you get to a cause determination. And I think that's a critical part of the component. We're always going to try to see if we can't conciliate the matter and come up with some sort of resolution shorter than a zero-sum game of a cause or no cause determination. I talked in one of the first couple sessions about how I had a case where we got a no cause finding after 6 months, and then a year and a half later, the case was reopened. Judith Keeler got hired by the Washington State Human Rights Commission, is my recollection, and HUD, the HUD office in Washington State, reopened the complaint, vacated the no cause finding, and then 2 years after the initial complaint filed, we got a cause finding, and then that case went to a federal court jury trial. It took us 5 years to get to the jury trial. And then after we had a 3-week jury trial in federal court, we took it to the Court of Appeals. Took us 2 years to get to the Court of Appeals. After we prevailed at the Court of Appeals, the tenants, who were represented by Gonzaga University legal assistants, tried to get certiorari to have the case heard by the United States Supreme Court, and that was denied. That case took 9 years from start to finish in my office, and filled up one of my office rooms with litigation boxes full of documents. So I think a lot of this stuff is fluid. My experience is the typical fair housing case is resolved in about 5 to 7 months, sometimes earlier, sometimes later, depending on what the caseload of the investigators are. And I have a fair amount of them, I guess, that have probably been resolved in the first 6 months. But I think you gotta just be ready for how it progresses and goes, and just kind of react to that. It's a dance, and I think the cases that are well documented in the landlord's position are the cases that are expedited and over quick. And I have had several cases over the years where I've been able to get the case dismissed within the first 2 or 3 months because my client had just rock solid documents and really had a great picture that they could paint for the investigator based on just really good documentation of all the events that showed that the complaint was not well founded. And I'll leave with this. I had an investigator tell me one time, and an investigator that I've done pretty well with, and she said, "Eric, I don't believe there are any frivolous complaints. I believe that everybody that files a complaint has a perception that they've been discriminated against. I just don't believe all those complaints are redressable under the law." David, if you could address that, and then the penalty phase.
Yeah, so just kind of in addition to what Eric had said, the HUD investigator really determines how quickly things are going to move. Out of the chute, they're going to ask for your documents. And that's a key point. And you'll get a chance to answer the complaint, which I know Eric and I spend a lot of time on, where you get to tell your side of the story. Some people take the strategy of providing very little information. If I have a case where the documents tell our side and we're correct, I lay it all out there. I attach it, I go into great detail, and I show them where we knocked the ball out of the park. Then that interviewer, in addition to asking for your documents, can do interviews. The investigator can interview very often. We'll have interviewed the complainant and their witnesses, if they have any, and we'll want to interview your property manager and maybe a regional manager or other witnesses that you have. So that can be very time consuming. It can push it out 6 months, I think is probably the average, but I've had investigations go almost a year. And a lot of things can change. The person can amend their complaint. The investigator decides they need to do a second round of interviews or ask for more documents. The key thing to know is that HUD process with the HUD complaint is not required. A person who believes they've been discriminated against must file that within 1 year of the event. if they're going to go the HUD complaint route and take advantage of the investigation and conciliation or an administrative law judge. But within 2 years after the event, they can go directly to filing a civil lawsuit, typically it would be in federal court, without going through the HUD process at all. So those are 2 timeframes to keep in mind. And in that, like Eric mentioned, is the conciliation process, which I'll talk about in a minute. But go ahead, Eric.
I was just going to say the value of having HUD champion your case and finding cause is you get that DOJ or the AG involved. And then what happens is the tenant will also have frequently private counsel in addition to the DOJ. So you can get a lot of lawyers on the other side. When I had that case that went on for so long that I told you about, there must have been, I went through, I think 8 or 9 different lawyers from the Department of Justice in the course of that case, because I'd have the DOJ lawyers would get reassigned after a year or 2. And then all of a sudden the attorneys that I had been dealing with from DOJ would be substituted out for new lawyers, and new lawyers would come in and have to get up to speed, which didn't help that case progress very well. But I think the value there is with that cost line is having DOJ do the lion's share of the work. And then the bad side about that is you have lots of attorneys on the other side that are trying to charge their attorney fees to your client. And that makes the stakes go higher, because David's going to talk to you a little bit about the penalties in housing discrimination cases. But in addition to that, there's frequently an award of attorney fees and costs.
In my experience, the civil suits, it depends on the complexity. In fact, federal courts ask the attorneys, is this a fast track case, or is it a medium track case or a slow track case, trying to figure out how is it going to fit into the court docket. And typically those cases are going to find their way to trial within 12 to 15 months, depending on the complexity of the case. And those are extremely expensive undertakings to defend those, because when you're in federal court, any court, but particularly in federal court, it's a no holds barred fist fight type of proceeding. And unfortunately, the result is often winner takes all. And that there's very little, either they're going to find no discrimination and the defendant prevails, or they're going to find discrimination and the plaintiff's possible recovery is wide open. Before I get to that, what could happen or penalties, I do want to mention something that just popped to mind, and I'm sure Eric will have some comments on that. And that's a topic called electronic discovery, which happens in court proceedings. And that is that what you have said in your emails to other staff, what has been said to your friends or your family about this issue you're dealing with, everything you said to the other side. The only person you could have communicated with that's protected would be communications with your lawyer, perhaps. But all of that would be discoverable in a case and would be known by the other side. And it's not that you're going to get to go through your emails and decide what to pick. But in federal court now, there are requirements whereby the other side might be able to send somebody, a vendor, third-party vendor, to come to your office, to your computer, and download your emails, download your memos, and so that the other side can have it in discovery. Now you can do it. Maybe your lawyer will do it to the other side, because it's usually both sides get this. But my point is, you can't vent about residents. You can't vent about a circumstance and let down that professional guard that we've been talking about. Because if there is a fair housing matter, what you say, unintended, thinking that most people think this is all private. It's not private. And they'll get deleted emails just as well as they'll get current emails. And I've just seen over the years defending it that, maybe we did everything correct. And we think that we can show that we did not violate the Fair Housing Act. But on the other hand, the other side can show that someone in our management had absolute disdain for this tenant and said some things that are, for lack of better terms, embarrassing. And lawyers hate to be put in that position. Managers hate to be put in that position. So that's just a real warning. That's part of that professionalism that on your professional site, your professional Outlook, your professional computer, you want to make very sure it's only professional electronic communication.
Great points, David. And where I believe this comes in a lot is the logs. And I was talking to you guys early on in one of the initial presentations about how critical it is to keep a manager's log. I always want a log entry on a general ledger for anything at the property that's suspicious or unusual. I also want those log entries making it to the tenant file for the specific tenants that are involved in whatever issues going on or conduct going on. But those log entries have to be above board and written in a way that you expect it to be reviewed. There's a motto a while back about act like everything you're going to say is going to be on the news, and what are you going to think if you see yourself saying it on the news? And I just think there's a lot of times where landlords, agents will make insidious comments, sometimes discriminatory comments in their logs, and it's just incredible to me. I coached hockey for a long time, or for a while, and I'll never forget, I had a couple of kids that did this locker room boxing stuff with their hockey gloves on, which is not allowed. And they did it at the ice rink where we skated. They videotaped it, and then they published it on social media. And I got them down, and I said, well, I can't believe you're so dumb that you did this deal here at our rink. I can't believe you're so dumb that you videotaped it. And I can't believe you're so dumb that you published the videotape. But you just got to be smarter than that, and you've got to be on your best behavior at all times. I think you can vent, but you better vent in a constructive manner using appropriate language, because if there's any racial epithets or anything inappropriate in those logs or messages, like David said, they're going to get discovered. Right now, we have an eviction moratorium through our governor in Washington State. I'm aware of a client who had the AG contact them and asked to see a bunch of their inter-office communications, and then found an inter-office communication where one of the owners or principals was telling the manager, try to collect rent, which is prohibited by our governor's proclamation. And the AG is latched on to all that information and documentation that they got through electronic discovery, like David said. And it's been a motivating factor in the prosecution against that client.
So guys, we've got it's not so much a question as sort of a serial novel in the chat feature.
Yeah. We were going to touch on the penalties real quick, Eric.
Okay, go for it.
Yeah, I don't mean to interrupt you, but because we had said, so each count of discrimination, you could have more than one, can be a penalty up to $50,000. And each person who is a victim of discrimination can recover for each count for which they're a victim. So if you have familial status discrimination, you might have a claim by the whole family. So you can see how this can magnify. But and of course, the attorney's fees and costs, if it's a penalty. But in addition to penalties, there can be damages awarded in, an ALJ, an administrative law judge, or a federal court will award damages. And those damages can be actual economic loss, expense that's been incurred. It can be pain and suffering, loss of enjoyment of life. It can be humiliation. All of which you can imagine if you deny somebody a assistance animal that you should have approved, and that person has lived a period of time now without that animal, creating hardship for them, that can be a substantial damage award. And a jury that finds out, hey, the law said you should have done this and you didn't, and then here's a person victimized by it, it's not a position you want to be in. It absolutely is not. Plus, again, the attorney's fees and costs on top of that. So it's if you're lucky, it's only the tens of thousands of dollars. If you're really in the mix, it's hundreds of thousands of dollars. Okay, sorry.
Okay,
Eric.
so I'm going to try and summarize this question from my good friend Leanne. Hi, Leanne. Thanks for putting this in there. So I'm going to kind of distill this. Basically, it's a tenant complaining about another tenant and putting the site manager in the position of being the go-between because they don't want to address the other tenant directly and won't put anything specifically in writing describing the problems. So, and they started calling the police and having the police come in. And once the police show up, there's really, it has to do with noise and odors and stuff coming from the tenant B's place. And when the police show up, of course, there's no noise and no problem. So, the first tenant requested a reasonable accommodation to be moved into a larger unit or to remove the offending neighbor and include a doctor's note that this was, going to be a reasonable accommodation for them. So, do you want to address that? And the complaining tenant's also given management a timeline to accommodate them, or they're gonna go to legal aid or probably some other advocate group. So that the management's trying to get the tenants to work this out between the two of them. It's a pretty involved thing. So Eric, maybe you're tracking this too.
Yeah, what I would do in a situation like that is one, and you've given me some left turns there, Eric, in the hypothetical, because you're saying that the tenant that's making the complaint refuses to put it in writing, refuses to give a whole lot of particulars, and you're saying that they call law enforcement and law enforcement can't corroborate the issues. In those situations, I really try to get my client to go out of the way to investigate the conduct that's being alleged to see if they can corroborate that it really is going on. And if you can corroborate that there really is a violation going on, then I would issue a comply or vacate notice under 6-303 of the Idaho Code and tell them, hey, either comply with your tenant duties or vacate. I think that you get into a lot of problems when you don't know the particular conduct and you can't verify it. And then in those situations, I'm going to be a lot less interested in issuing a compliance notice if I can't ascertain what the conduct is. I'm a real stickler in my practice to make sure that when we issue a comply or vacate notice or a termination notice for conduct, that we are very particular in alleging conduct that occurred when, where, how, and why. And if we can't make those allegations a particular fact, I'm not going to go forward just on a conclusion. And I got to tell you, when I get complaints that say that my neighbor is noisy 24/7, I don't think much of it. That's a conclusory complaint that doesn't include particular details. What I need to know are what I need to know is what is going on, when, how, and then have it preserved and hopefully be preserved by multiple different sources. And it's only when I can preserve that I'm willing to take action. And if they want to go and lawyer up or do whatever, and they're not giving me particular details of conduct, which I get from time to time, I get these cases, but they don't have a hell of a lot to stand on. And I think sometimes it benefits us when they do get a lawyer, because then we can get the lawyer to help articulate what the particular facts are that are at issue. And if I can't get any of that done, then I'm going to probably write the tenants letters and refer them to mediation and tell them to mediate their disputes and behave. And I might look at, the reasonable accommodation to get a larger unit because of a noise complaint sounds a little suspicious to me. I don't know how you get a larger unit just because there's a noise complaint, but I might look at trying to relocate the parties or something like that if I think it's a personality issue or something like that, and we have the ability to triage it through that sort of situation.
And there's a follow-up on there. It says that the object of the complaints has been there since 2004. No one else has ever complained about them until this new tenant moved in. So it sounds like maybe a personality issue.
And you got to look at this from the totality of the circumstances of what's going on here. And if this is just somebody that wants to live without neighbors around them, well, they might have chosen the wrong place to live.
Yeah. So there's another
for conduct.
We got another question about a tenant that's constantly taking photos of other tenants. Example would be taking pictures of children that play in the snow, and then taking those photos to the property manager with captions to say, look at these kids making a mess of the walkways and making noise. And the folks that are being photographed, they claim they feel violated. Then, so the basic question is taking photos of other tenants allowed, or is it a violation of privacy?
It's certainly a form. It can be a form of harassment where the person who's being photographed objects to it, and that objection is communicated to the person doing it, and they refuse to stop. That would, and here again, if you've got a good set of rules that prohibit one resident from harassing another or disturbing their peaceful use and enjoyment of the property, then taking pictures of people who've asked you to stop is certainly a form of harassment. I wouldn't go right out and go after lease termination. I would give a couple of warnings and build a case if this person refuses to stop, and then proceed on that basis. Yeah.
I think those are good points, David. I think that you have to also look at the context of the surveillance. What I'm seeing a lot more frequently is people that are running surveillance cameras into parking areas. And if I look at those situations and I look, does the lease or rules prohibit even putting up or erecting surveillance activities? Some drug dealers put surveillance cameras on their front door just so they can see who's at the front door and whether they're going to open the door to sell drugs. So that's a dynamic there that's sometimes restricted through some of the rules I see. But I look at the context of where the surveillance is occurring and what's being surveyed. Is it a common area where there's no expectation of privacy, or is it some area where there might be a higher expectation of privacy? I think if it's directed at children and at somebody that might be a little more vulnerable, and it's not being done in a real limited, good faith, positive way. I mean, it's one thing to take pictures of kids in the snow. It's another thing to do it every day and to follow them around and do all sorts of other stuff. And then I think you also have to look at it is the conduct that's being preserved through these photographs, is that conduct in violation of tenant duties? And if the conduct is in violation of tenant duties through the release of the rules, then I think there's a lot better purpose for that photography or surveillance to be going on. But if the conduct's benign and not a violation of the rules, then I think you're getting into the harassment realm like David talked about.
Somebody asked, I saw one of the questions was, they're taking pictures of children. Isn't that against the law? I'm not aware of any law that says you can't take a picture of a child who's out in an area available to the public. I think here again, it's harassment. If the parent says, I don't want you taking pictures of my children, you do not have my consent, and then I think you've got a argument that it's harassment for the person to continue.
Okay, and we've got a follow-up from Graciela on the privacy rules and laws. She's saying, what about the ring type doorbell, where you've got the, it's built into the doorbell, it's a surveillance camera. Is that kind of what you're talking about, Eric?
Well, no, I've seen that, but I've also seen people that'll just put a surveillance camera above the door or in a window by the door. When I look at the new doorbells that have the cameras in them, then to me, that goes to the alteration of equipment. And does your state code or does your lease or rules prohibit the tenant from altering the equipment or the amenities at the property? And if they do, then it's probably not correct for them to replace the doorbell with the surveillance camera unless there's something else going on there, But that's one way to control that. But if your lease and rules are silent on that, then they might be able to do it. And quite frankly, I don't have a real problem with a camera in the doorbell. That's kind of where technology is going. I don't have that at my house, but I sure wouldn't mind it.
So I've got a question that's sort of out there a little bit, but it has to do with who has standing to file a fair housing complaint. And it's a case that Terry Catay told me about years ago when we were doing a kind of a regional fair housing training tour of the state. And it has to do with Trafficante versus Metropolitan Life. And that was a really early fair housing case. It looks like 1972. And that had to do with two tenants in a complex who filed a complaint against the managers and owners for a pattern and practice of discrimination. And the claim they made was that the landlord was racially discriminating against non-whites, and that the two complainants, who were both white, thereby lost the social benefits of living in an integrated community, missed business and professional advantages that would have accrued from living with members of minority groups, and suffered being stigmatized as residents of a white ghetto. That one, that was a pretty big deal back in the day. And I guess I'm curious, do you see that precedent ever coming up in cases these days? I mean, it's been a long time.
Yeah, so yeah, that case is pretty well known. And I would say that it reaches out there and tests the far boundary of who is a victim of discrimination. Certainly far further out there than you see. I've never seen a case similar to that actually in Idaho. Usually it's pretty clear who the person is, that the person has standing who's alleging the basis for the discrimination. But it goes to show that the Fair Housing Act is interpreted broadly. And there are thousands of cases, if not tens of thousands, that say Fair Housing Act is interpreted broadly. It's remedial. It's out there to correct something, and we're not going to cut it off at some point in time. We're going to let the facts of each case take us to what the boundaries are. And in the case that you mentioned, Eric, they obviously found it to extend further than what you would typically see in your run-of-the-mill case.
What I encounter most of the time, David, is people that think that the claim facilitators like Intermountain Fair Housing Council don't have standing, and they absolutely do. And I've actually seen some lawyers respond to complaints suggesting that these agencies don't have standing, which I just think is a pretty novice mistake. But yeah, I think an aggrieved individual is anybody that's been impacted, and I don't think the threshold's that high. I think David's right. You got to be wide open. I haven't I think I've handled a couple hundred cases. I don't know the exact numbers, but I don't remember ever getting out on one because of standing.
I haven't seen an assistance animal file suit yet, though. that would be.
That'll be the dog friend of the assistance animal.
Yeah, but haven't seen that one yet, but maybe the boundary is somewhere around there.
So David, I've got here's one for you. I think we've got about 13 minutes left. I think you're familiar with this case, but it has to do with a landlord or property manager who had someone request an accommodation for an assistant or for a service animal. At least he called it a service animal. And what the person was asking for was an accommodation for an assistance animal or an emotional support animal. So the guy, the landlord, did his research based only on the definition of service animal, and then denied the request because he felt that the animal hadn't received specific training to perform a task as a service animal under the ADA would. Do you want to talk a little bit about the importance of making that distinction and understanding that whether it's a service animal or an assistance or a support animal, folks need to be really cautious about their response?
Yeah, and in fact, it's such an important distinction that the most recent guidance in January of this year from HUD brings it up and probably makes it somewhat confusing. In fact, they endorse what the most recent guidance endorses what the landlord did and what you just described, and that most recent guidance from HUD says that if somebody calls it a service animal, then you apply an ADA type analysis to it. I actually don't agree with that part, in that I think practically speak, maybe in a theory that's correct, but I think you're going to run into the problems that the landlord did in this most recent example. And that is that an animal that isn't trained as a service animal may still be permitted under the Fair Housing Act, even though it's not trained. So you're drawing a distinction that really has no difference and is based upon a layperson, a tenant or an applicant, describing the animal in a certain way. An animal that is not trained can still provide a service to the applicant or resident that makes that a permitted animal under the Fair Housing Act. So I think the correct analysis is what we've talked about, is you start and begin with the broad definition of an assistance animal, which is service animal and or comfort animal, and do your analysis from there. If it's a service animal and the person does that, and shows that, obviously that animal's in, that's great. But if the person doesn't hit that high bar required under a service animal ADA requirement, that's not the end of the analysis. The end of the analysis only comes when you say, okay, does that animal, does this person have a disability, and does that animal alleviate some part of the disability that makes housing more available to this applicant or resident? So I never approach them from applying an ADA type analysis to start with. I always go with the assistance animal. Eric's got his hand up.
Yeah.
Yeah. So what I think there's a couple issues here to talk about and break down. One is you got to kind of ferret out the request, and they're saying service animal, but I think they're using some different technical nomenclature in the incorrect way, And I think if you look at the FHEO 2020-01 released on January 28, 2020, which is the document that David's referring to, it talks about a series of questions. I believe there's 8 questions it walks you through. And the first line of questions are, is it a service animal? is it a dog, and they get through disability. Then you get to, is it a dog, is it trained or does it perform a function? And then it says, if you can't reach this, then it's not a service animal. But FHEO 2020-01 says, but you're not done. You continue in the assessment to determine if it's an assistance animal. So I think it's a progression, kind of like David alluded to, in evaluating all this information to decide whether or not ultimately you have to grant the accommodation. But don't let the tenant's request necessarily dictate the end result just because they've not formulated the request correctly. And I think you really want to go to that FHEO 2020-01. It's such an interesting document. I was talking to Ken Nagy this morning about it on the way to work. We were jawing about it. And it's a best practices document. It's not the law, but I guarantee it's going to be used to evaluate liability in the very near future. And it's going to be a tool. And it's a tool, like David said, I think creates as many questions as it answers. So I've spent a heck of a lot of time with that document, and it's interesting.
Yeah, I think Eric and I would both tell you that if you have a request for accommodation for an animal, regardless of what it's titled, and that you have a verification that the person has a disability, and you have a verification of a nexus between the disability and something this animal provides to the tenant. That's all it is, a nexus. This animal provides comfort. This animal helps him find his shoes in the morning, whatever it might be. If you're going to deny that because you think the person is requesting a service animal and this doesn't, in your mind, satisfy an ADA type analysis, you better have somebody else look at that, because they can't measure how thin the ice you're on at that point in time.
And I think the tenant sometimes may be confused about the terminology and
Sure.
and may use service animal interchangeably with assistance or comfort animal. And I put that 2020-01 link in the chat for everybody too. And I think the thing to keep in mind is, I think Christina Miller's the one that sort of has articulated this, that if you've got somebody with severe anxiety disorder, PTSD, depression, sometimes an animal can give them a reason to get out of bed in the morning, or can help them feel calm enough to function, in society or at all. And so it does serve a real purpose in terms of that nexus. So it's important to be thoughtful about that. And I think Terry Kate once used to say, the correct response when you receive a request is, we consider all requests for reasonable accommodation, and then take a real hard look at it and call one of you guys or somebody else who can help you decide what course of action to take. So we've got about 5 minutes. Any other questions in that folks want to submit in the chat?
Eric, I'm sizing you up to be about a 41 or a 42 rag right. I'd be interested to know your height and weight to get that down. Know if I got to go short or long on that coat.
Well, you've got some competition. My father-in-law used to own a chain of men's clothing stores in South Dakota, so my wife grew up in the business too.
Okay.
So maybe I'll connect you two, and you can compare notes.
I'll even make it easier. Just get him to put on a tie, I think would be.
So, not to change the subject, but do you guys want to talk any more about fair housing? Anything else you want to wrap up with? Any kind of words of wisdom for folks who are maybe looking at policy decisions in their company, things like that. And I guess we see a reminder from Christina that if you want a certificate, please email her at christinac@ihfa.org. We had some folks that maybe didn't see that link in the last session, so I want to make sure you pay attention to that. And we do have a question about limitations on the type of animal that can be considered an emotional support or service animal. So Eric, want to tackle those? And
Yeah, two things. One, FHEO 2020-01 talks about animals, says that assistance animals really need to be domesticated animals unless there's a unique need for an assistance animal outside of that. And then you've got to have a doctor or a licensed professional healthcare provider is the best practices to verify that this person has a unique disability or disability-related need for a specific animal that is not typically a domesticated animal. The HUD FHEO 2020-01 defines a service animal as a dog now. They removed miniature horses from the equation. So a service animal can only be a dog. An assistance animal should be a domesticated type of pet, small animal, not a reptile for the most part. And if it's going to be something other than that, then you've got to have a unique commentary from the verifying individual, qualified verifying individual. And the last comment I wanted to make to you in wrapping this up is that this should not be your last training session. And just because you attended these training sessions doesn't mean you're done. It's a fluid process. It's a continuing education process. And you need to be committed to these fair housing principles and how they're going to evolve.
Yeah, I would certainly agree with everything Eric just said. And I think we're going to be doing this next year, so you can come back again. I think it's important. This can be a daunting body of information, and people can feel like they ought to make a career change after they attend fair housing training, because it seems like a lot. But I think if you step back, take a deep breath, take some of what we've told you today about communication, professionalism, just good management skills, and know the warning signs. Don't be afraid to go get help. Everybody makes mistakes, just don't compound them. And documentation, there are just some themes here that if you could write them down on just one piece of paper and keep them on your desk or keep them handy, it would be invaluable to management after today until we can get together and have some more training. And so I would just go back to often what I close with is that a large percentage of the people that you manage and work with appreciate your work. Don't let this become your sole focus or drive you from enjoying your job or your work. Stick with it. It's going to just be part of the landscape forever from this point forward. And the way to management is to let people like Eric and myself be part of your training and preparation, and make use of IHFA's Fair Housing Forum when you need that resource.
Okay, we got one, it's 2:00 now. We do have one last follow-up on that assistance animal or verification. Somebody that says, what would you do if a manager refuses to accept letters from a therapist or physician for an emotional support animal?
I didn't hear the first part of the question.
It is, what would you do if a manager refuses to accept letters from a therapist or physician for an emotional support animal?
I'd fire the client.
Pardon?
Fire the client. I'm not going to go down on that ship.
I would advise them to correct that immediately, to accept those, and that person would be so far off that I would advise them to see me and help me steer them through that particular issue, and that they go take HUD's fair housing training ASAP. That's what
the other thing is I'd try to get to the owner in that case. If I had a rogue manager that's blatantly disregarding the law, I'd try to get in touch with the owner and let them know, hey, we got a problem here, and somebody that's gone rogue and not following the law. Eric?
Okay, well, I think we're probably ready to wrap up. And I just want to, again, thank everybody for participating. I want to thank the two of you for presenting and sharing your knowledge about this. And we'll be looking at another series of 3 sessions in the spring of 2021. So we'll make sure that everybody on this session has information about that. And who knows, we may attack, you know, some more HOA specific questions in the spring, or some other things. So feel free to send us questions. We'll be glad to you know, kind of chew on those for next year. And again, if you have any suggestions for information you'd like to see at fairhousingforum.org or at IHFA's Fair Housing page, I've put those links in the chat. Let us know, and Christina can help you with the certificates. So please, you know, send her an email, and we'll get you those. And then we'll send out a quick follow-up survey just to get some feedback from all of you to see how we can improve these next time we do them in the spring. So thanks to everybody. Have a great holiday. Stay safe out there, and you know, hope to check in with folks later.
Thanks, Eric.
Okay, thanks you guys.
Thank you, David.
Yep, happy Thanksgiving.
Yep.
You
See
too.
you guys.